that's everything from me. I'll hand over to you two. Thank you.
Great. Thanks, Nancy. Morning, everyone. For those of you who aren't familiar with us, although I do assume that most who are joining the call will be, we are Goodwill. We are a management consultancy who have been assisting companies expand and scale in the UK for over 25 years. To date, we've worked with more than 2,000 businesses across a range of industries, and we offer a complete solution encompassing corporate governance, finance, payroll, virtual office, and of course, human resources. So today we have myself, I'm the head of HR for Goodwill, and I'm joined by Helen Watson, who is a senior advisor in the team. And we are here to talk to you about how you can navigate the movement of people into the UK workforce. So I feel like we've been speaking about this topic for years because, well, we have post-Brexit, but it is a changing landscape, hence why it comes up continually, pretty much on an annual basis. And of course, our current government have not disappointed. They are looking to switch things up again just to keep us on our toes. So Helen and I will be giving you a high level view of that today. In terms of the agenda, so today we'll be talking about the general right to work in the UK. We'll be talking about UK immigration pathways, sponsorship types. We will be talking about right to work. We'll be talking about the business visitor visa, sponsorship license requirements, and common blockers and delays to get a sponsor license in place. Also, as promised, we'll be talking about the upcoming changes to immigration, as I've just alluded to. And then finally, secondments. So I will hand off to Helen to kick us off.
Thanks, Jacqui. First of all, I wanted to talk about the general right to work in the UK, and the piece that I'm going to start with about is how it stands at the moment. Jacqui's already said that the landscape is going to be changing, and we'll cover off a very high level piece about that at the end. But as it currently stands, there were lots and lots of changes post-Brexit. So it essentially means that EU nationals were to be treated the same as non-EU nationals in terms of the right to work. So what that means for you and in terms of all businesses in the UK is that you should be asking every individual who comes to work for you and is currently working for you, if you don't have it on file already, their right to work. So there's various ways that they might be able to provide that to you. They might hold a UK or an Irish passport, or they might be sponsored or hold a visa through another route. But the most common ways you will find are providing you the UK passport. An Irish passport also gives individuals the eligibility to work within the UK via the Common Travel Area. We also have the EU settlement scheme. So that was put in place to support those already in the UK and working who are EU nationals prior to the Brexit changes. You've also got student and graduate visas. So quite often they will have restrictions attached to them. So it might well be that you have someone on a student visa, but they can only work 20 hours per week, for example, during term time. And graduate visas will have a set time limit to them that's normally 1 or 2 years. You've also got the global talent visa. So this is for leaders in their field. It's quite a specialist area, and they have to have lots of evidence to be able to prove that they have that talent and that they are able to apply for this type of visa, but it is available and it is out there. And then you've also got dependent visas. So that means that they have a member of their family is sponsored within the UK, and then they are provided with a dependent visa. And again, once you check their right to work, if they've got any restrictions on that, then that will flag that to you, and you'll be able to see that. But if you've got any questions on any of those and any specific questions, then we happily pick that up with you and support you on that. So the next piece I wanted to talk about was UK immigration pathways. So the pieces that I've just talked about doesn't involve sponsorship, by companies. So the previous slide was a visa or the right to work that an individual would hold, and it's not attached to a particular company. The next piece I wanted to talk about was the immigration pathways and the piece about sponsorship. So there's lots and lots of different routes that you could sponsor people, but the most common that we come across and that we can support with are the skilled worker route, the senior specialist or global mobility piece, and the UK expansion worker. So I'm actually going to start with the UK expansion worker, and that's designed for overseas businesses that are coming to the UK and establishing in the UK. So that you don't currently have a presence in the UK, you're not trading in the UK, but the purpose of this visa is to come and set up and expand your business within the UK. There's quite a lot of compliance with lots of these routes, but particularly with the UK expansion worker piece, because you're looking at the overseas entity, you're not established in the UK at the moment. The next piece I'm going to talk about is the senior specialist, so the global mobility piece. There's a limited list of occupations that you can sponsor via this route. It's far, far shorter than the skilled worker, and it doesn't count towards residency. So if the individual that you're sponsoring has a thought or an idea that they want to remain in the UK long term, we're talking long term, this particular route doesn't count towards their residency. The minimums that we're talking about in terms of salaries are higher than the skilled worker route, but there is no requirement currently to undertake an English language test through this particular route. And then finally, we've got the skilled worker route. So that's much broader in terms of the types of roles that you could be looking at sponsoring. The salary requirements are less than a senior specialist, and this importantly does count towards residency. So if someone has a long-term ambition and aim to remain in the UK, then the skilled worker route does count towards their residency, and they would be able to provide that to support their application if that's what they want to do in the longer term. So there's lots of different routes, but these are the three most common that we come across, and we're going to talk about the changes that are coming, but there's going to be quite a few changes to a number of these routes. So it's important to think about where you might want to be now in the business, but also reach out to us if you've got any questions, particularly coming in the future as well. And I'll hand over to Jacqui to talk about the next piece.
Thanks, Helen. So I think Helen's going to talk a little bit later about the actual setting up of the mechanisms of the sponsorship routes and the common pitfalls that we find around having the relevant personnel that are in place to allow you to apply for sponsorships. So hold out for that. However, we are commonly approached by our clients to tell us or inform us that employees will be coming to work in the UK for a short period, or we're asked if they can, in absence of them being able to get a sponsor license in place. And because there is commonly a misconception in terms of what the business visitor visa can be used for. So we are often approached about this, or as I mentioned, informed that personnel will be coming to work in the UK for a short period, so up to 6 months, and that they'll be travelling under the business visitor route. So we just wanted to clear up a few misconceptions in terms of what this route can actually be generally used for. So for clarity, the business visitor visa is a non-sponsorship visa. It sits under the standard visitor visa rules. So in essence, it permits non-UK nationals who aren't coming to the UK under one of the permitted routes that Helen has already spoken about, excuse me, to travel to the UK for up to 6 months. However, the business visitor route can't be used for work in the traditional sense of that word. So there are restricted permitted activities which can be carried out when someone is in the UK as a business visitor visa, as a business visitor. And the UK government website has got a comprehensive explanation what the business visitor visa can and can't be used for. So I know we do have a slide that has those listed. If we can maybe just have that as a visual, Nancy, please. Thank you. So your employees can come to the UK under this route to attend interviews, meetings, conferences, seminars. They can come and negotiate and sign deals and contracts. They can attend trade fairs to promote the business, but they can't sell things. That is a key element of that. They can get work-related training if that training is not available in the home country that they are residing in. And they can also deliver training or share knowledge on internal projects with UK employees of the company that is the UK company linked to the overseas company that they work for. So if as an example, you have very company-centric activities or a way that you work, and you need someone to come over from the parent company to teach the newly appointed UK staff, then they can come to the UK on this route for that purpose. They can give one-off or short series of talks as long as they're not for profit or at a commercial event, which is going to be revenue generating for you as a company. There are exceptions to that. So if an employee would be speaking at a permitted paid engagement, so UK Gov has a comprehensive description of what they deem a permitted paid engagement to be, but in essence, that means that the person coming to the UK on that visa type would need to be a leader in their field, and they would need to be invited in writing by a UK company that is asking them to come to the UK to give that talk. Your employees can also carry out site visits and inspections. They can oversee the delivery of goods and services provided by a UK company to the overseas company or organisation. And then they can also come and install, dismantle, repair, service, or advise on a company equipment, or it could be tech or hardware, if the overseas company has a contract with a UK company or organisation. So it is possible to carry out those activities as long as they are within that specialised list. So essentially the person can't be engaged or paid by the UK company as another important point. So they can't be receiving payment in the UK as an employee or a self-employed person unless they are coming on that permitted paid engagement, which I mentioned. So they would still need to be engaged by the parent company, and they would be receiving salary outside of the UK for that period when they're in the UK. So there are a restricted list of roles where someone can work in the UK and carry out typical working duties for their position, provided that they are engaged with a company overseas. So that, again, it is restricted, and we are looking at positions such as if someone is a journalist or they are a PA, as an example, or we've also got on the list on screen a scientist or a lawyer. Again, if they are engaged through the parent company to carry out their duties in the UK for that period of time. But again, very short list. So the take home is, for most employers, if you need someone to come and work in the UK for up to 6 months, if their activities are outside of the permitted duties, which are extremely clear on UK Gov, then they're going to need an actual working visa, which they would obtain themselves via their own, if they have that avenue, or they would need to be sponsored by you as a company. If you do find that the business visitor visa is going to work for your needs, then depending on the country that the employee is traveling from, then a visa application itself might not actually be needed. So, for instance, employees traveling from Sweden, Finland, or the USA, as just a few countries being named, they don't require an actual application for the business visitor visa, but they do need an ETA, so I'll be talking about that shortly. But for example, those traveling from India would need to make a business visitor visa application. So again, there is a section on UK Gov website for you to check where your personnel are coming from and whether they would need that business visitor visa. If they do, then the application cost is £127 at this time. So I mentioned the ETA. So that is the new electronic travel authorization technology, which was rolled out recently in the UK. And effectively, this is like the UK version of the US ESTA, and it's needed by all persons who are wishing to travel to the UK. So even as a tourist, someone would need this. If they don't have another means already of gaining entry to the UK. So again, obviously, such as a UK passport or a sponsored visa, or they are here under the EU separation agreement under the settlement scheme. So all of those things that Helen talked about as well. So if they don't have that, then they are going to need an ETA. And the ETA itself is linked to a person's passport. So while the ETA in itself does not guarantee entry to the UK, border control are absolutely still going to ask all of their questions. The idea is that this ETA will permit someone to enter the UK and stay for up to 6 months, so the same rules as the business visitor visa, provided that they are not breaching any of the immigration rules, which I've already spoken about. So the idea is that there will be a clear way to electronically track comings and goings. Border control are going to have a really clear view on border crossings. So if you have someone who is coming and going to the UK frequently, or they're spending large amounts of time here, then we can expect that there will be more questions asked at border control. The cost for the ETA is £16. And it will last for 2 years. So it's linked to a person's passport, as mentioned. It lasts for 2 years, but if the person needs to replace or renew their passport in the meantime, then they will need to apply again. So bear that in mind if your business travellers are going to need this ETA, then they will need to have this in place before they travel. And we also, on another point, we also recommend that if someone is traveling on this basis, that it's wise to maybe have a letter that they are carrying from the parent company, again, especially if they're a frequent traveller, to detail what they are doing in the UK, where they're staying, to reduce the potential for border control denying entry. And then I also just wanted to very briefly cover off when you might need to sponsor, because sometimes that can be a bit misunderstanding there as well. So, um, of course, if you're bringing someone from overseas to work, and again, they don't fit into any of the categories that we've already spoken about, we do know that they need to be sponsored by you. So if you're bringing someone from overseas to work, including someone you were transferring from the parent company or a brand new hire that you need to gain entry to the UK, you're going to need to sponsor them. This is a one that we do get commonly. So if you find local talent in the UK and they are already being sponsored by another UK employer, to be clear, they will lose their visa and right to work when they leave that company. So their visa is tied to their previous company. It doesn't transfer with them. So you would need to have a sponsor license yourself as a company to then apply to sponsor that person under your sponsor license. Helen's already touched on it, but graduate visas, they typically do last up to 2 years. The UK government are looking to make a change to reduce that, but there is no recourse for an employee on a graduate visa to stay in the UK once that graduate visa expires. So they do need to find an alternative route to work in the UK, and the likelihood is they would need to be sponsored by you. So just be aware of that. And then also, if someone has a dependent visa and then they may lose this because the main visa holder who their dependent visa is linked to has maybe lost their job, or they cease to be employed by their employer and the Home Office have curtailed their visa in the UK, then just be aware that that might be an instance where you might need to sponsor the employee as well. And that's a little bit more difficult to track because, of course, you are dependent on the employee being honest with you that that's happening once you've done your initial right to work check that Helen had mentioned earlier. So on that point, I will pass over to Helen.
Thanks, Jacqui. So we've spoken a lot about visas and visa types and at what point and when you might want to consider getting sponsorship licenses in place. And I just wanted to give a really high level piece about what the requirements are in order to get a sponsorship license in place and the common pitfalls that we experience with our clients. So first thing is to think about what type of visa routes that you're going to be applying for. And we recommend that if you're thinking about multiple visa routes and your plans are over the next 12 months to utilise those visa routes, is to apply in one go, in one application, rather than applying for those different visa routes piece by piece. The other thing to really think about and to make sure you have in the UK, because these are the two biggest sticking points that Jacqui and I come across when we're talking to clients about sponsorship licenses, is about key personnel. So you need to have an authorising officer and a level 1 user based in the UK. The authorising officer must be senior enough in the business to have oversight of hiring. If the Home Office decide to do an audit or to question the business, this is the person who will be answering those questions. So they need to have visibility and oversight of hiring, be able to answer financial questions, and be able to be that right person in front of the Home Office. Level 1 users must also be based in the UK and have the right to work in the UK. And there's been a recent change at the beginning of this year in terms of they can't be sponsored. So there's limitations of who that could be in the UK. So, for example, they need to be a UK passport holder or be here on a EU settlement status, as an example. Once you have the license in place, you can outsource a level 1 externally. So Jacqui and I are level 1 users on some of our clients' sponsorship licenses, but you still need to have an internal level 1 user. And then the other big sticking point that Jacqui and I come across is bank accounts. So you must have an FCA and PRU approved UK bank account. So the likes of Wise, for example, and currently Revolut don't meet this criteria in order to have a sponsorship license and be able to start that application. So we're talking about more high street bank accounts as we would know them in the UK. And as I've mentioned, compliance is really critical. So the Home Office can scrutinise your application for the sponsorship licence. They can ask questions at any time. They can turn up and audit you at any time once you have the sponsorship licence in place. So you need to make sure that you're meeting all of your compliance pieces, that the authorising officer, as I say, is the right level to be able to answer those questions. And in our experience, if the Home Office do ask questions, you don't have a lot of time to answer them. And again, they can just turn up and do spot checks. So you need to bear all of those things in mind when you're looking at putting a sponsorship license in place, and once you have them, meeting and keeping your compliance up to date. Next slide, please. And Jacqui and I have mentioned throughout the presentation so far that there are lots and lots of changes to come. The government released a white paper a few weeks ago in terms of proposed changes, and I just wanted to give a really high level of what that might look like. So they're going to increase the skilled worker route and increase it to graduate level roles. So as I mentioned from at the beginning, there's lots and lots of positions that are currently covered through the skilled worker route. They're looking to cut this substantially and limit them to graduate level roles. They're going to be increasing the salary thresholds. It was increased fairly recently in the last couple of years, but they're going to be increasing that again. And the immigration skills charge is going to be increasing by 32%. For the skilled worker route, they're going to be increasing the English language requirements. So once someone sits their English language tests, their baseline for that is going to be increasing. So we're recommending clients to look at their needs now. If you don't have a sponsorship license in place and you think you might need one, then seriously look at getting that in place now. And also look at your cohort of employees. Who are you sponsoring at the moment? What recruitment plans have you got over the next 12 months? Because we don't know when these changes are going to happen. We don't have any timelines at the moment, but we do know that costs are going to be increasing, and particularly on the skilled worker route, the breadth of roles is going to be cut as well. So it's important that you look at what you currently got and look at your recruitment plans over the next 12 months or so. So I'll hand back to Jacqui to talk about the next piece. Oh, no, that's still me, sorry. So I also finally wanted to cover off the changes for dependents and student visas and some of the future proposals. So as I mentioned, dependents and students aren't tied to a sponsorship via an individual company, but they still do have to prove their right to work. So they're going to implement a new English language test for dependents, and that's going to be rolled out in increments. But at the moment, there's no requirement to do that. So that's going to be new, and they're going to roll that out. And as Jacqui mentioned, we're going to be looking at graduate visa durations to be cut. So at the moment, that you can be on a graduate visa for up to 2 years, and they're looking to cut that to a maximum of 18 months. But they are looking to expand the global talent visa pathways. They're going to look to include science and design in that piece at the moment. Currently, there's quite a lot of limitation in terms of the pathways that you can look at for that, but they are looking to expand that through to science and design. And as I've already mentioned, there's no time frames on these changes at the moment, but we are recommending that clients look at what you've currently got and what your plans are for the next 12 months or so to see what you need to be doing right now. Hand over
Thanks,
to
Helen.
Jacqui.
Thanks, Helen. Okay, so I'm conscious on time. We've only got about 5 minutes left. So I wanted to talk very briefly about a non-immigration matter, which is secondments. Of course, someone needs the right to work to be able to be seconded to the UK. But when we think about secondments, it's the nature of the person's engagement in the UK, and effectively the benefits to a secondment for the employee tend to be centred around their tax and social security treatment. So if you didn't already know, the UK have reciprocal agreements in place with many countries, most countries actually, which in short means that if an employer wants to send an employee to the UK, excuse me, to work for a short time, so this would be up to be able to benefit from the tax treatment on a secondment. They might want to consider sending them on a secondment and not as a new local hire. So firstly, it's important to understand your agenda as the employer. Like, do you actually want to retain that person in the home country's employment or not? But also you need to understand the employee's intention. So does the employee want to move permanently? Do they see this as a short-term move for them? And if it is a short-term move, then a secondment would certainly be a consideration for you, because presumably that secondee would want to stay in the social security and pension system in their home country. So that would definitely be a perk for them. So effectively, the main crux of this setup would be that the secondee is still employed by the overseas employer, but they are seconded to the UK employer as their host employer on a temporary basis. So when that secondment ends in the UK, they return home to their home country employer, and there is no break in that employment overseas. If someone is moving and seconded for up to 2 years, as mentioned, then we would always recommend, of course, that they have a tax meeting. That employee would need a tax meeting with a tax advisor to assess their tax residency status for the UK. So that advisor would also look at any foreign income that they may have as part of that assessment. And provided that the tax analysis is positive on this, then the person who is on a temporary assignment, known as a secondment in the UK, then they can claim temporary workplace relief on their temporary living costs in the UK. So this is for items such as rent, utilities, even food bills. If someone can be bothered to save their receipts, it's possible to claim on that. But that effectively means that they can receive temporary workplace relief, which is up to 80% rebate on those temporary living costs in the UK. And if they've brought family with them, like a spouse and children, that further reduces by, I think it's 10% for an adult and 5% per child. But it's still, of course, a perk. And again, it also means that the secondee can remain in as a home country employee. It means that they can stay in the home country's social security system. They don't pay UK national insurance. And they stay in the home country pension scheme, and they're exempt from the UK workplace pension scheme auto enrolment in the UK. So do let us know if this is something that you want to explore. From speaking with many clients about this, sometimes it's the first that they've ever heard of it. So we just thought it was worthwhile raising as a relevant topic today. I think that's us done for our main presentation. Do we have any questions?
We haven't had any through. Oh, we have. Can you see those, Jacqui?
Yes. Okay. I think, Charlotte, you've asked, do graduate visas count towards residence? No, they don't. So if someone wanted to remain in the UK, they would need to go on a skilled worker, actually, because senior specialist worker doesn't count towards residency either. Okay. We've had a question from Arishi. Do you help in procuring the sponsorship license for a company or skilled worker visa for a candidate? So for clarity, Goodwill can help apply for a sponsorship license. So as Helen touched on, we can, our governance department can help set up a sponsorship license application on behalf of the company, but you still need personnel internally, as Helen has outlined, to fulfill those key roles. Goodwill can be an external level 1 user to help you manage that license. We can apply for certificates of sponsorship through your sponsorship license as that level 1 user, but we don't apply for your employees' visas. That would be the end part to the process where the employee applies for a visa directly themselves. Okay, and then I think we've had on secondments, assuming they stay in the same social security and pension system in their home country, does the employer need to pay for national insurance in the UK? No. So provided the home country payroll, so as an example, if the employee was coming from Sweden, it would be the Swedish payroll that would apply for an A1 form in the home country, and then that would that the employee would have that, and the UK payroll, who was running the shadow payroll, would see that, and they would exempt the employee from paying national insurance and the company from paying national insurance in the UK. Is it possible to go the visa route once a person is in the UK on secondment? I'm not really sure what's meant by that question. Because to be in the UK on secondment, they would need to have the right to work and have a passport, or a British passport, sorry, or here on the UK settlement scheme, or they would need to have gained the right to work in the UK via sponsorship. So secondments and sponsorship are separate, but they're not mutually exclusive, because you need the right to work to be in the UK on secondment. So presumably they have the right to work in the UK. If they have another means, like they lose their dependence visa, as an example, and they're here on the UK working for you on secondment, then which would be a bizarre situation. I don't know why I've chosen that example, but theoretically, if that happened, then yes, they could be sponsored by you if they're already here. Helen, I don't know if you've got any thoughts on that one.
Yeah, Jacqui, there's just to follow up on that. So if they want to extend past the 2 years, so assuming they've got the right to work via sponsorship or another route here on secondment for 2 years, and then they want to stay for another 2 years, I think that's the question.
Right, okay.
Yeah.
Yes, but I guess the key thing on that is they would likely lose the perks of secondment. So they would lose their right to claim temporary workplace relief. So once there is an intention to stay beyond 2 years, then you're not allowed to claim temporary workplace relief. So it wouldn't affect someone's ability to be in the UK and to work, provided that the Home Office approved their ability to stay. That's fine. But the tax treatment which is still relevant in a scenario, depending on how you wanted to treat that and to benefit from that, the temporary workplace relief would be lost.